Hello everybody, welcome back to yet another episode of our YouTube channel, Law Point. This is me, Praseena Elizabeth Joseph here. As we all know that internet has become an inevitable part of our daily life. It is difficult to think of a life without the internet, and so the comments exchanged among the public over the internet can also be a source of defamation. To speak more about this, we have Supreme Court of India's advocate on record, Mrs. Praseena Elizabeth Joseph, to explain the defamation and cyberspace.
The platform provided by the internet has made human interaction easier than ever before. However, such increase in convenience of communication has proportionately increased the inconvenience caused by the abuse of freedom of expression in the internet. For example, posting any defamatory statement such as unnecessary or false statement against a person or an entity with an intention to defame him in any social networking site such as Facebook, Twitter, etc. harm that person's goodwill and reputation. Further, the word that we colloquially use, trolling, actually amounts to cyber defamation. Cyber defamation is when a computer is connected to the internet which is used as a tool or a medium to defame a person or an entity. Cyber defamation is one of the many cyber crimes along with credit card fraud, hacking of computer system, software piracy, child pornography, etc. Although there are laws in place which prohibit people from posting such defamatory content online, most people are either not aware of it or are too negligent to realize whether such content is defamatory or not. Liability of cyber defamation is first of all on the author of the online defamatory material, that is, the person who is posting the defamatory content online. Secondly, the liability is on the service provider or intermediary. Basically, if you are posting a content in Google, Google is a service provider. If you are posting a content in Facebook, then Facebook is a service provider or intermediary. If you are posting the content in Twitter, Twitter is a service provider or intermediary. Likewise, intermediary or service provider includes any online payment sites, other websites, etc. Now, let's see what are the legal provisions which regulate cyber defamation. Although the media of committing defamation in physical and digital world are different, the same law of defamation is applicable in both cases. The provisions of Indian Penal Code as well as provisions under Information Technology Act apply to cyberspace defamation. Sections 499 and 500 of the Indian Penal Code, which deals with defamation and punishment for defamation, are applicable to cyberspace defamation. Apart from that, if a person creates a false online document or a fake online account with an intention to defame the reputation of a person or an entity, then Section 469 of the Indian Penal Code, which deals with punishment for forgery, that is imprisonment up to 3 years and fine, is applicable. Further, if any person by use of electronic means damage the reputation of a person in society, then he will also be liable under Section 503 of the Indian Penal Code, which deals with the offence of criminal intimidation, where the punishment is sentence of imprisonment for a period of 2 years or with fine or with both. If this imputation or the defamation is towards the unchastity of a woman, then the punishment is enhanced to imprisonment for a period of 7 years or with fine or with both. Now let's see what are the provisions under the Information Technology Act which deals with cyberspace defamation. Earlier there was Section 66A of the Information Technology Act which provided for punishment for sending offensive messages through a mobile, computer or tablet. However, the word offensive was very broad, wherein the government was using it as a tool to repress freedom of speech and expression. So, the Honorable Supreme Court of India in the year 2015 was pleased to hold Section 66A of the Information Technology Act as illegal. Till date, the Parliament has not come out with a proper definition for the word offensive, so the punishment is still under Indian Penal Code provisions. Further, Section 79 of the Information Technology Act, which protects intermediaries such as Facebook, Twitter, Google, etc. against a defamatory content generated by public on their platform. This protection can be availed on two conditions. First of all, the intermediary was only a facilitator and they have not initiated or modified the defamatory content. Secondly, the intermediary need to remove the unlawful content on being notified by the appropriate government or its agency or upon receiving actual knowledge. Any person aggrieved of cyber defamation can lodge a complaint with the Cyber Crime Investigation Cell of Police in every city. When one complains to Cyber Cell, the agency looks into this issue, and if it finds that the content is defamatory, they will direct the intermediary to remove the unlawful content within 36 hours. If the person is still aggrieved, then he can initiate court case against both the person who generated the defamatory content as well as against the intermediary who still has not removed the defamatory content.
Thank you so much for watching our video. Stay tuned.